Hong Kong Stock Exchange Directors Training. Responsibilities of directors of companies listed on the main board of the Hong Kong Stock Exchange. Issues of new securities. 1. Preemption rights. One of the primary aims of the listing rules continuing obligations is to ensure the equal treatment of all shareholders. A key aspect of this is to ensure that member shareholders are not diluted by the issue of new shares to third parties. Under Mainboard Rule 7.27b, the issuer cannot undertake a rights issue, open offers, or specific mandate placing, individually or aggregated, within a rolling 12-month period that would result in a dilution effect of 25% or more. An exemption from this requirement is possible under exceptional circumstances. For example, the issuer convinces the exchange that it is in financial difficulties and the proposed capital raising is needed to rescue the company. The exemption does not, however, apply to open offers. Otherwise, Mainboard Rule 13.36 (1) provides that, except in the case of a pro rata offer to existing shareholders, the directors of a listed issuer must obtain the consent of shareholders in general meeting prior to the allotment, issue or grant of shares, securities convertible into shares, or options, warrants, or similar rights to subscribe for shares or such convertible securities. Alternatively, Mainboard Rule 13.36 (2b) allows a general mandate to be obtained from shareholders at a general meeting of shareholders to issue shares, convertible securities, or rights to acquire shares. The general mandate must be subject to a restriction that the maximum number of securities which may be allotted may not exceed 20% of the number of the company's issued shares as at the date of the resolution granting the general mandate. If a share consolidation or subdivision is conducted after the approval of the issue mandate in the general meeting, the maximum number of securities that can be issued will be adjusted accordingly. The general mandate can also separately authorize the company to issue shares equivalent to the number of shares repurchased since the date of the mandate, up to 10% of the number of the company's issued shares as at the date of the resolution granting the repurchase mandate. A general mandate granted under these rules will lapse at the end of the next annual general meeting, unless it is renewed by ordinary resolution passed at that meeting. General mandates can also be revoked or varied by ordinary resolution of the shareholders in general meeting. The initial conversion price of convertible securities issued under the Mainboard Rule 13.36 (2b) must not be lower than the benchmark price as defined in Mainboard Rule 13.36 (5) of the shares at the time of the placing. The issuer cannot issue warrants, options, or similar rights to subscribe for its new shares, or any other securities convertible to its new shares, for cash consideration pursuant to a general mandate. The restrictions in Mainboard Rule 13.36 do not apply to pro rata offers, unless it is an open offer, provided that the pro rata offer is made to all existing shareholders, excluding shareholders resident in a place outside Hong Kong, which the directors, after making inquiry as to the legal restrictions under the law of such a place and the requirements of the relevant body or stock exchange, consider it necessary or expedient to exclude because of such restrictions or requirements. The circular or offer document must contain an explanation for the exclusion of such shareholders and must be delivered to shareholders excluded from the offer, subject to compliance with the local laws and regulations. In view of the listing rules restrictions, notices of annual general meetings generally include a resolution granting a general mandate to the directors to issue shares, other than on a pro rata basis, up to the permitted maximum amount, i.e. 20% of the number of issued shares, plus a number equivalent to the number of shares purchased, subject to a cap of 10% of the number of issued shares at the date of the repurchase mandate. Listed companies can also call an extraordinary general meeting, EGM, to approve an issue of shares for a specific purpose. A company which has obtained a general mandate may also refresh the general mandate at any time before the next annual general meeting. However, the company's controlling shareholders, i.e. holders of 30% or more, and their associates, or, if there are no controlling shareholders, the company's directors, other than independent non-executive directors, and chief executives and their associates, are not allowed to vote in favor of the refreshment. In addition, the circular to shareholders in relation to the proposed refreshment of the general mandate must set out 1. The company's history of refreshments of the mandate since the last annual general meeting, and 2. The amount of proceeds raised from the resolution of such mandate, 3. The use of such proceeds, and 4. The intended use of any amount not yet utilized and how the issuer has dealt with that amount. The restrictions in Main Board Rule 13.36 apply equally to listed companies incorporated in Hong Kong and those incorporated overseas. They do not, however, apply to an overseas listed issuer whose primary listing is on another stock exchange, which is not subject to any other statutory or other requirement giving shareholders preemptive rights over further issues of shares. 2. Restrictions on issues of securities in 6 months after listing. A listed issuer is prohibited from issuing or entering into an agreement to issue any further shares or securities convertible into its equity securities within 6 months of the commencement of the dealing in its securities on the exchange, whether or not the issue will be completed within 6 months from commencement of dealing, except for 1. The issue of shares, the listing of which has been approved by the exchange pursuant to a share option scheme under Chapter 17. 2. The exercise of conversion rights attaching to warrants issued as part of the initial public offering. 3. Any capitalization issue, capital reduction or consolidation or subdivision of shares. And 4. The issue of shares or securities under an agreement entered into before the commencement of dealing, the material terms of which are disclosed in the listing document issued on the initial public offering, Main Board Rule 10.08. 3. Issues of securities for cash. Where a company's directors agree to issue securities for cash, whether under a general mandate or not, the company must publish an announcement as soon as possible and no later than 30 minutes before the earlier of the start of the morning trading session or any pre-opening session on the next business day. The announcement must contain the information set out in Main Board Rule 13.28. In the case of a placing or open offer of securities for cash consideration under the company's general mandate, the issue must not be at a discount of 20% or more to the benchmark price of the securities. For this purpose, the benchmark price is the higher of a. The closing price on the date of the relevant placing agreement or other agreement involving the proposed issue of securities under the general mandate, and b. The average closing price in the 5 trading days immediately prior to the earlier of 1. The date of announcement of the placing of the proposed transaction or arrangements involving the proposed issue of securities under the general mandate. 2. The date of the placing agreement or other agreement involving the proposed issue of securities under the general mandate. And 3. The date on which the place or subscription price is fixed. Main Board Rule 13.36 (brackets 5). The exception to this rule is where the company can satisfy the exchange that it is in a serious financial position and that the only way it can be saved is by urgent rescue operation involving the issue of new securities at a price which is at a discount of 20% or more to the securities benchmark price, or that there are other exceptional circumstances. Where securities are issued for cash under a general mandate at a discount of 20% or more, the company must publish an announcement giving details of the allottees no later than the commencement of trading on the next business day after the agreement involving the proposed issue is signed. Main Board 13.29a. If there are less than 10 allottees, the announcement must include the name of each allottee or its beneficial owner and confirmation of its independence from the issuer. If there are more than 10 allottees, the name of each allottee subscribing 5% or more of the issued securities must be stated, and a general description of all the other allottees, together with a confirmation of their independence from the issuer. In calculating the 5% limit, the number of securities subscribed by the allottee, its holding companies, and their subsidiaries must be aggregated.